Today by the U.S. Supreme Court, justices ruling that police can collect DNA from criminal suspects without a warrant. The vote, a very close one, 5-4. Now, the ruling involved a Maryland case where a man was convicted of rape based on a DNA sample taken during arrest on an unrelated assault charge. The justices concluded that DNA swabbing does not violate the Fourth Amendment, which protects people from unreasonable search and seizure. Joining us now via Skype to talk more about this, Kwame Thompson. Hi, Kwame. How are you?
Hello, I'm doing fine. Thank you.
That's very good. Kwame, you're a defense attorney in Atlanta, so this really affects you. What's your reaction to today's ruling?
Well, I'm not surprised by this ruling. There's been a string of case laws that have come from the Supreme Court in this line of litigation. One has to differentiate between the search of a person and the search of a place. Detainees and people who are arrested expressly for those who have been arrested for felonies and violent crimes have diminished personal rights, and their rights to their reasonableness when it comes to seizures and searches is different than one that you and I may have.
That's right. And technically, I mean, every criminal who's out in the system right now could actually be swabbed and matched for previous crimes at this point. What do you think about that?
Well, I think there's a lot of backlash because the reason that the Supreme Court today ruled that the case or this statute is reasonable is because they state that it is important today to identify criminals. And today's identification goes beyond fingerprinting and then a name on a social security card, for example. The identification is going to be a part, well, the criminal history is going to be a part of that identification process. And it's going to actually do a lot of good. It's going to solve a lot of unsolved crimes, and it may possibly lead to a lot of people who are free from unlawful arrests and detentions.
I can imagine. So the vote, though, closed 5-4. Do you think this is it? Do you think this is going to come back again? Will this stand?
Well, I believe that there may be some challenges. Actually, from here, I think that the legislature is going to take a look at these actual laws. For one example, all 50 states already have such laws in place, and the dissent was very strong in stating that they believe that the majority's argument that identification was a rules and not really a true argument, and that what we're entering into is a police state. But fingerprinting went through the same type of analysis under the Supreme Court over 100 years ago, and with DNA and with technology, it's just a very much so a part of our society today.
All right, Kwame, thank you so much. We appreciate your insight, and we will see what happens with this. Thank you.
Thank you.